Hello, everyone. The Ontario government has announced that it is monitoring bidding wars in Ontario, including multiple representation. Accordingly, it's very important that all realtors in Ontario follow the rules regarding bidding wars and try to make them as fair as possible for all buyers involved. This is for the benefit of everyone, because it appears as though the government may completely ban double ending by a salesperson as a result of their monitoring, and they will try to do away with what are called phantom offers, or when listing salespeople appear to mislead buyers about the number of offers received. And so it's very important that all bidding wars be conducted in a proper manner. So here are some common questions that I receive regarding a bidding war. Number one, what should I do when the seller is holding back offers for 3 days? It is very important that you still try to have the home inspected by your own home inspector before the buyer puts in an offer. With condominium transactions today, I am reviewing many status certificates in advance so that buyers can put in an offer without condition. And home buyers should do the same thing. If the home buyer refuses that, you should remember to use AREA Form 127 and get the client to sign it, confirming they understand the risks involved when they put in an offer without condition. Number two, should a seller conduct a pre-listing inspection and make it available to any buyer? Well, you see, with a condominium, almost everyone is doing that. With a home, there is debate whether the inspection should or should not be provided to potential buyers. Some say that this could get a seller in trouble if there's a mistake in the home inspection report. In my opinion, as long as the report is not made part of any agreement of purchase and sale, it is extremely unlikely that a buyer would be successful in this type of action. And in my experience, more disclosure usually results in more offers from interested buyers. So please remember to discuss this with your sellers and your buyers. And a note for buyers: even if a seller leaves you a home inspection, you should still conduct your own home inspection to make sure the home is in good condition. Question number three, is it okay to present a bully or preemptive offer? So in other words, if offers are called for next week, you still can present an offer tonight to the seller. The thing is, the seller does not have to consider that offer. And so if you're acting for a seller, you must be careful to explain what a seller could perhaps give up by taking a preemptive or bully offer before the offer date. Next question. If the seller has completed AREA Form 244, which says they will not look at offers until next week, can they still look at an offer? Well, in my opinion, when you're completing Form 244, you should put in some language to the effect that says that if an offer is received early, the seller will be contacted for further instructions. And that way, you can discuss at that time with the seller the pros and cons of looking at a bully offer in advance. You may be leaving money on the table. There may be other buyers who've already booked home inspections, and they'll be left out of the process. And so the key is to explain everything properly to your seller in order for them to make the decision. If they want to see the offer early, remember, you must change MLS to note that offers will be looked at immediately, and you should also contact any other salesperson who has expressed an interest to let them know that the rules have changed. In addition, you must make sure that your seller has signed something that says that you can now bring an offer earlier. Number 5, what should you do if you are the listing salesperson in a probable bidding war and a buyer approaches you, perhaps at an open house, asking you to represent them? Well, here, going forward, the government may just not allow you to represent them. And so, in my opinion, you should consider the following steps. Number 1, have another agent in your office represent that buyer. Number 2, make sure that all bids are sealed before the presentation to the seller. 3, have a manager in your office present all offers to the seller. 4, you may consider not permitting any buyer brokerage to reduce their commission in any offer, so that you will not have to go back and make this disclosure to all other buyer sales representative, which, in my opinion, typically upsets the dynamics of a bidding war. And finally, you may want to include a statement that escalation clauses, which I will discuss in a few moments, are not permitted with any offer. Next question. What if you're suspicious that the seller is not telling you the truth when they say that they have another offer coming in or they're expecting another offer? You must remember that the listing salesperson is not necessarily misleading. They're saying that they're expecting an offer. It doesn't mean they've received an offer. And if you have no choice but to email your offer to the seller beforehand, you may want to consider using my own bidding war clause that is included with this material. In the bidding war clause, it says specifically that you're only making this price offer because you're in a bidding war. It goes on to say that if it turns out later you're not in a bidding war and the seller does not receive any other offer, then you get to change your offer or withdraw it. And in my experience, most buyers are able to cut their offer by a minimum of 5% when this happens. It goes on to say that if the seller accepts your offer, they must give you the name of the salesperson and brokerage company that submitted the other offer. So you can check, even before the deposit is payable, whether or not there was a second legitimate offer. What about escalation clauses? I will pay $5,000 more than the highest offer received. The Real Estate Council of Ontario has recently sent out a bulletin saying that these clauses, while they don't endorse them in any way, are legal. In my opinion, they are not. And the main reason is that under the Code of Ethics, a listing salesperson is not permitted to disclose the substance of any offer to someone else. Now, if somebody says, I will pay $5,000 more than another offer, not to exceed $500,000, and the seller comes back and says, well, the escalated price is $455,000, well, then the seller really has disclosed that the other offer was $450,000, which in my opinion is not permitted. And I believe that another buyer in the bidding war could bring a lawsuit against the listing salesperson for being part of this disclosure. And so for this reason, I strongly believe that you should not permit escalation clauses in any offer, and it must be disclosed to everybody before the bidding war starts. This is what the government's going to be looking at anyways. How can we make a bidding war fair for everyone? And this is the lesson I want to leave you. With my partners at Lawyers.ca LLP, we are now able to close real estate deals across Ontario. and we appreciate your continued trust in referring your clients to us. If you have any questions about bidding wars or any other topic, please call me directly at 1-888-876-5529 or email me at mark@realestatelawyer.ca. Thank you.